And we are just about to resume now with Ian Denham, who's joined very kindly by Simon Richards of Digby Brown. And I'm told that they are the Batman and Robin double act. So I'm very much looking forward to this talk. Ian, as all of you will know, is now the England and Wales representative of Pupil, which is very, very exciting. Simon has been shooting through the ranks, I think, of the tier one Digby Brown firm, the largest personal injury firm in Scotland. I think he's obviously Mr. Cross-Border when it comes to all matters involving Scottish nationals or other nationals, I think, being England and Scotland. So looking forward to hearing your talk. Thank you very much.
Thank you. There's going to be a bit of a double act. There's going to be a fair bit of me to start off with. And the good news from those of you who last saw me speak in Copenhagen is there's going to be no audience participation. The bad news is it's going to last slightly longer than 3 minutes. If you were there, you'll know exactly what I was talking about. Next slide, please. Here's the agenda, which Simon is blocking out for those who are here.
The agenda is just me.
And that's what we're going to hope to get through to start off with. I've tried to include as much Wales as I can England here, knowing that Mark was going to be joining us. So to start off with, there's going to be a bit of dry law. Next slide, please. And it's just a reminder of what the provisions are of Section 4 of the Civil Jurisdiction and Judgments Act 1982. This is probably the set of jurisdiction rules which have enjoyed the least attention over the last few years for obvious reasons. We're all familiar with the contents of the Brussels regulations, which sadly we are no longer with us apart from existing cases. And of course, over the last year or so, we've all been fixated with how the CPR jurisdictional gateways work, and in particular the tort gateway, and Sarah's success, along with Dan and Josh in Brownlee in the Supreme Court. However, Brownlee still lives on in a guise through our friend, Section 4 of the Civil Jurisdiction and Judgments Act 1982. It's not a direct lift of the Brussels regulations, but there are similarities there. And these are the rules with regards to allocation of jurisdiction within the 3 jurisdictions of the United Kingdom. So long as we still remain 3 jurisdictions. And we can see, just as an example, contract under Rule 3A, the default rule under Rule 1, mirroring Brussels, is the person domiciled in the part of the United Kingdom should be sued in that part. We then have the exceptions from Rule 3 through to 9, most of which as personal injury practitioners aren't particularly relevant for us. So I've tried to pick out the ones that are particularly relevant for us. So there's Rule 3A, contract, the place of the performance in question. That should be relatively self-evident. Tort, the place where the harmful event occurred or may occur. Now, the important thing to remember here is that this is a lift from Brussels. So Brownlee and the Brownlee interpretation of indirect harm and direct harm, as David was referring to earlier, doesn't count here. This is our Brussels harm. So even though you might have an individual who, for example, sustains the initial injury in an accident in Scotland or Northern Ireland and then continues to sustain the majority of their losses back in England, that is not the question that we're looking at. We're looking at the initial harm, and that's what we mean by the harmful event. There are, however, additional provisions, for example, for multiple defendants. So there may well be, say, an anchor defendant in England. I was recently advising in a clinical negligence matter where there were 2 very closely intertwined allegations of negligence, one against an English NHS trust, one against a Scottish NHS trust. Arguably, the harm happened north of the border, but they were so inextricably linked that we would be looking to run an argument to say that England was the correct forum on that basis. So there are some examples there of the basics of the intra-jurisdictional rules within the UK. Next slide, please. Simon and I were discussing, starting off, as we both looked through Schedule 4, we noticed this sudden loss of double dots and being told something had been removed. And the slightly cynical part of me did wonder whether or not Brexit had resulted in there no longer being any rules with regard to consumer contracts or employment rules. Fortunately, I remember that, in fact, the news is better than that. And our British attempt to continue some part of the Brussels legacy was contained in the Civil Jurisdiction and Judgment Amendment EU Exit Regulations 2019, which, and one could say this is British arrogance or otherwise, continues to maintain the consumer contract provisions as per Brussels regulations and the employment provisions as per Brussels in domestic legislation. Of course, what it doesn't have is the benefits of the Brussels regulations. So there's no reciprocal provisions, there's no recognition, there's no enforceability which goes with all of that, but it makes our lives considerably easier, both within the United Kingdom in terms of arguing jurisdiction with consumer contracts and employment contracts. And what we will also have the benefit with is being able to use CJEU judgments up to the 31st of December 2020. So all of that useful jurisprudence from the European Court of Justice, particularly focused on consumer contracts with targeting business towards the United Kingdom, still holds strong now. Now, there is a potential risk for divergence in the jurisprudence moving forward, but that should be helpful. So particularly in consumer contracts, you can sue the defendant in their home court or the consumer's home court, provided that you can tick those relevant boxes. So that's good news, but that also applies intra-UK as well as it does across the whole wide world. Next slide, please. What don't we have? We don't have an Odenbright regime domestically, which is a bit of a pain. So not quite sure what the logic for that was, but we don't have one. We don't also have an overt lis pendens and related actions provision, the equivalents of rules 29 and 30 in the Brussels recast, which set out very clearly when proceedings had to be stayed and when you couldn't continue to pursue actions when there were similar actions started in another state and dealing with when particular states were seized. We do, however, have the provisions which remain in section 49 of the 1982 Act even, can't read my own notes, which does allow the court to stay proceedings on the basis of forum non-conveniens. Next slide, please. Which then brings us to the cautionary tale of Cook and Virgin Media. I started off my life at the bar on the Northern Circuit, and apart from my early trips to Carlisle, usually involving battles against litigants in person, usually moaning about mould in their homes and various other issues of housing disrepair, I also noticed that, that not all the claimants up towards the border, either in Newcastle or Carlisle or wherever else, were from Cumbria or Northumberland. There was a lot of Geordie up there, but there were also a few Scots. Why was that? Well, it was because there's a good number of English claimant firms who are not just looking forward to acting for the good people of England and Wales within the courts of England and Wales, but also like to sign up as many Scots as they can. It's not unknown that cases, personal injury cases involving Scots in England, no matter where they're issued, tend to end up in Carlisle. This led to the learned district judge in this particular case, of his own volition, striking the cases out. Now, it's important to note that in these two conjoined appeals, in neither case was there a challenge to the jurisdiction under Part 11, and in one of the cases, liability had been admitted. Nonetheless, the district judge, who made it very clear that Carlisle was not the county court for Scotland, considered that although there may have been a technical right pursuant to Schedule 4, it was still a question of whether or not it was appropriate for the actions to be heard in England as opposed to Scotland. The claimant appealed the striking out and failed at first instance and at second instance in the Court of Appeal. And one of the important things to note in that is the Court of Appeal made it clear that it was not necessary to challenge the jurisdiction under Part 11, and Section 49 could be used either being raised by the parties or by the court of its own volition to strike out a case on forum non-convenience ground if it considers it appropriate. So that's the jurisdictional rules. Next slide, please. You'll be pleased to know that the focus on applicable law is much shorter. It's Rome 2, it's Rome 1. That's the law, and we can move on. Next slide, please. Now, we're going to start moving on to some actual Scottish law, and I have some thanks to give before I carry on. First of all is for Scott Rigby for instructing me on the matter of Johnson and Berenson, which I've worked together with both Sarah and with Jared McDermott KCs. Also to Angela Graham KC, who was our original expert on Scottish law, Andrew Clark KC, who really annoyingly then got promoted up to the
He's now Lord Ordinary.
Lord Ordinary, and our most recent KC on the case, Jonathan Brodie. I'm not an expert in Scottish law, but through osmosis, I'm picking a fair amount up.
And WhatsApp.
And WhatsApp, mostly through my secret expert, Simon Richards. They have some funny words for things north of the border, and there's some things that are very similar, and there are some things which are just damn right weird from an English perspective. And what we hope to do is to guide you through some of those. I'm focusing in on the beginning, the case of commencement of the proceedings, because, well, that's where proceedings start, and you really want to make sure you get that bit right. The orthodox approach up to the decision of Mrs. Justice Tipples in the case of Pandia and Intersalonica was that the substantive law did deal with limitation when it started, its duration, how you could extend it, and by what procedure was needed for it to be commenced. But in terms of domestic law, the procedure, that was the bit which dealt with the how you started the proceedings. So it's accepted that our general view is, and if you look through the textbooks which predate Pandia, which I did at length, there's no suggestion to say that it was anything other than the law of the forum, the procedural law, govern the how you commence the proceedings, including, I may say, the rather wonderful April Guide to Accidents Abroad, which was cited and put before Mrs. Justice Stacey, which was not written by a member of these chambers, I may add. So there wasn't anything partial about that. So when Mrs. Justice Tipples in Pandia, which was a Greek case where the limitation period was 5 years, said you had to not just issue, but serve within the limitation period, that came as a bit of a shock. And it came to a particular shock to us in Johnson because we had issued proceedings in time, but not served, but Pandia hadn't been held down at that point. The sneaky defendants, and they were sneaky on many, many ways, which I know Chris will understand as well, and I'm not going to go into all of the sneakiness in that particular case, raised a lot of issues, but they particularly said that we were statute barred because we had not commenced proceedings and passed the signet and various other things within the triennium. We didn't really know what that was. And we ran off to Scottish lawyers to ask what exactly that meant. And we discovered there was Section 17 of the Prescription and Limitation Scotland Act 1973, which says that limitation 3 years, great. And it said something about a signet. And we didn't really know what that is. Now, Simon, would you like to explain what passing a signet is?
Well, that's nice and easy. That's a good start. So when you are raising proceedings in Scotland, you are going to do so either in a sheriff court or the Court of Session, which is our equivalent of the High Court, which has got one of them. And if it's a summons, it will be signeted, effectively stamped. And if it's in the sheriff court, it will be warranted and again stamped.
Thank you.
Do you want me to go on?
If you'd like to.
Well, then the principal thing is the commencement of proceedings date in Scotland is not the date of it being signeted or warranted, it's the date of service. So an action is not commenced until the point at which it is served, which can give rise to rather large problems, as Ian is about to tell you.
So We valiantly, Jared and I, spring 2021, tried to argue before Mrs. Justice Stacey that Pandia was wrongly decided. She was having none of it, despite us finding some absolutely brilliant cases and putting forward some rather forceful legal arguments on all of that. So there we are, we're stuck with that. So the message is, if you've got a case in Scotland, do what Simon just said, and you should be all right. That's, of course, if you've not already handed it over to Simon to run in Scotland. Next issue, next slide, please, is just considering whether or what the position is with regards to extending the limitation period. Now, of course, we don't always want to do this, but it's, for example, in clinical negligence cases, it might be something that you want to agree or potentially seek an order on. The usual, of course, is that you start proceedings and then seek extensions after that. But this came through a chat Simon and I had at the end of last week. So, Simon, what is the position with regard to extending the limitation period under Scots law?
It's a nice, easy one, which is generally just don't do it. So there is an act, the Prescription Scotland Act 2018, which applies to the quinquennium, just to give you another term, which is non-personal injury-related claims have 5 years. That's our prescription period. You can, under that act, extend by a year by agreement, and that will bind the courts. Unfortunately, the act does not apply to personal injury cases. You cannot extend the 3-year period. What you might find in practice is if you're close to settlement, you can informally agree an extension with an insurer, but the court isn't bound by it. And there has been an authority roughly within about the last 5 years where the court went, well, that's great, you've agreed that, but we're holding its time barred, so goodbye. So the general rule of thumb is get it litigated, get it signated, warranted, and get it served before the triennium. And then you can continue your negotiations and simply pause the court procedure if you wish to. That's the sensible way of proceeding.
And next slide, please. So the second half of the battle we had to have in Johnson, which we did prevail on, was seeking the court to essentially extend the limitation period or use its discretion to allow us to continue. That was pursued under Section 19A of the Prescription Limitation Scotland Act 1973, which, as you'll see on screen, deals with issues of equity. And we had great arguments over all of that as well. And one of the issues that was raised is that in Scotland, if you miss the limitation period, you're effectively already de facto negligent. And that would lead to the claimant having a professional negligence claim directly against the negligent solicitors. Of course, this was less straightforward because, of course, we've talked about the orthodoxy pre-Pandia, Pandia coming out. So in this particular case, we were looking at different factors, one of which was in Glasgow, which was the accident which arose out of the bin lorry going berserk in Glasgow a few years back. But Simon, what are the positions in terms of seeking an extension if you do find yourself in that position north of the border?
Seeking an extension or of trying to have Section 19A applied?
Both.
So I think I've already kind of roughly covered seeking an extension, we just don't do it. Really just don't do it. In terms of Section 19A, I think you were really lucky in Ian's case to have an English judge deciding on Section 19A, because traditionally Scottish judges don't like applying Section 19A. They generally like to just simply refuse it. You have to have really good arguments to say why Section 19A should be applied. I was discussing with Ian earlier, one of the big kind of topics in Scottish litigation just now, we've got rid of the time bar for child abuse cases. And the reason the Scottish government had to do it is because all our judges kept saying, nope, Section 19A doesn't apply. They should have brought this action by their 19th birthday. And therefore, all these poor people who were coming out, as most victims of child abuse do, in their mid to late 30s, were being told, well, it's your own fault. You should have sorted this out in your late teens. I suppose the one thing I didn't cover in terms of limitation and the triumphs, 3 years from your 16th birthday, so up to your 19th birthday if you're a minor, for those that don't know.
I think
Extend my wishes.
and I think what the impact of that will be now post Johnson, and given that Pandia is really an issue which should be known by all cross-border lawyers now, is if you do fall into that trap, whether or not it's seeking an extension under Scots law or another law, to say that you didn't know, I think that's going to be a much more difficult argument to run now than it was. And it was the one, I mean, we approached Johnson feeling confident, but we felt very confident on that particular issue for all those reasons. Next slide, please. Liability. Now, I'm going to stop wittering on about Johnson because it is an ongoing case now. But what is apparent is, for example, in RTA cases, is there's really very little difference in terms of liability, mostly because an awful lot of English tort law comes from the Supreme Court, and some of them, believe it or not, come from Scottish cases, and those that has that universal application. But the one thing I did just want to focus on is in terms of proof of foreign law. And we've had the recent guidance obiter from Lord Leggett, paragraph 148 of the Brownlee judgment, with regards to challenging the orthodoxy that expert evidence must be produced by way of an expert report and opening the gates to other ways. I recently read an interesting article concerning the commercial court guides and section H3, which maybe not all of you have recently picked up on. And what that does, although strictly not relevant to the Queen's Bench Division and the County Court, is it does encourage flexibility with regards to how to adduce expert evidence on foreign law. And this can include dispensing with joint reports. So each side get their own report and you go straight into cross-examination. That sounds quite exciting. You get a report and then you just deal with them by way of submissions. That could deal with end an awful lot of stress on the lawyer's point of view, at least in terms of trying to get joint reports right, and cross-examination of experts, which Dan and I know from our recent trips to Liverpool can be an awful lot of fun, particularly when Dan's tearing my expert to shreds. Limit expert evidence to just identifying the source of law and then deal with it by way of submissions, or having no experts at all and just identifying the sources. So the penultimate one there was the experts identify what the source is, but they don't give an opinion on the law. And the other one is that you just identify the sources. Whether or not Queen's Bench Division will adopt those approaches or whether or not you can use them by analogy moving on in the future, we'll have to wait and see. The article I read didn't really give much guidance or confidence with regards to how that's going to be approached, but we can see there's going to be a flexibility in the future, perhaps maybe with cases, for example, involving Commonwealth law. Eliot and I have currently got a case in regards to law of Gibraltar, and we've established really not that different. So that's just a factor to consider with establishing what the foreign law is. But generally speaking, Simon, unless you think there's anything to talk about liability differences.
What I suppose I would say is, in terms of liability, is that a lot of the common law tends to be the same if it comes from case law. We do have different statutes. So you'll find our Occupiers Liability Act is different from the English Occupiers Liability Act. Our Animals Act is different than your Animals Act. There are random weird differences that you'll find, sometimes more beneficial to those in Scotland than those in England, that you need to be aware of. You can't just presume it's the same. The thing about Brownlee, I think Ian was alluding to, was the idea of pleading and proving foreign law and how you go about that. Funny for us, because I think that we had a decision in 1973, Bonner against Balfour Kilpatrick, which said you have to plead and prove foreign law. And that was affirming a decision from about 1880 something. And it always just been assumed that's what you need to do. With our procedure, which we'll get into later, that there are issues with that because we have an abbreviated form of pleadings. So how much do you have to put in to prove the foreign law? But that's pretty much for this. So yes, a lot of liability is the same. How we go about proving it, slightly different. And there are quirks that you need to be aware of that will be different. I don't know them all myself, but I know some of them.
Next slide, please. Now, quantum is different. Having drafted up a long schedule on Scottish law, some of it's very similar, some of it's very different. From what I understand from the eminent KC's expert reports I've read, texts like McGregor and Kemp are used, the Ogden tables are used, but the discount rate is minus 0.75%, which is good if you've got a Scots law case. Next slide, please. Now, what we're not going to try and do is go through every conceivable head of loss under Scottish law, but we're going to try and pick up on some which I've identified are different that you might need to be aware of. And the first one is salation or general damages. And I think Salatium has a similar approach to what it's supposed to compensate for. But Simon, starting off with, what's the approach to quantifying Salatium? And for example, do you use the guidelines? Do you use reported cases? And do you ever look at English reported cases?
Answer most of that is yes. So yes, we do use judicial guidelines. They're persuasive. They don't have to be followed. The general rule of thumb when looking at English decisions is they tend to be slightly lower than Scottish decisions. We tend to see our awards for Salatium as being slightly higher than what you would get in England and Wales. Largely in part that's because we get more things to what we would call a proof, you would call a trial, simply because our procedure is much faster, so things get rammed through. So we get many more decisions on them. Also, we have the benefit of jury trials. They all generally will award more, but of course we cherry pick what we take to a jury. Don't take a back pain case to a bunch of people sitting on a wooden bench for 2 weeks. They'll not be very happy with you. They'll simply not sympathize. So we would generally say we have slightly higher awards. McGregor on damages, yes, you might occasionally hear it referred to, not particularly all the time. I suppose it would have to be a niche argument. Kemp and Kemp, I think we have a copy in the office, but whether or not anyone utilizes it is a different matter. We effectively have our own version, which is McEwen and Peyton, which were two Lord Ordinaries that clubbed together to put that there. So we have a kind of own wee version of Kemp and Kemp. But pretty much in terms of valuing Salatium, we do it in much the same way that you do, which is looking at previous court decisions and coming to a conclusion.
How does, you say that, I'm just going to fire questions.
Fire questions from behind.
How does a jury quantify Salatium? What would an advocate need to do?
Well, that has changed. There is a case referred to later on in the slides. So back in the day, and not that long ago, up until 2012, a jury could just effectively pick a figure out the air. The skill of an advocate, or a barrister, as many of you are here today, would simply be to say, here are the figures I would like you to make an award. And a claimant's advocate, I want to say pursuer, so I'm trying to use English terms. If I go badly wrong, let me know. So a claimant's advocate would be suggesting obviously higher values, and a defendant's advocate would be suggesting much lower terms or figures, and then the jury can just decide. And if the jury went manifestly wrong, you would seek a new trial from the inner house, the appeal court. But effectively, they didn't used to have guidelines. In 2012, after a spate of jury decisions in fatal claims, the inner house of the Court of Session decided that they really should have guidance given to them prior to making decisions on what they should be awarding for Salatium. They aren't bound by the guidelines. So generally what is supposed to happen is both counsel for the opposing side would give what they think the guideline should be to the judge. He would advise the jury of that, but they could still pick a lower or a higher figure. And I think recent history tends to suggest, certainly in fatal claims, they have actually gone above the suggested valuations. So it's really, that's it.
Okay, one more question.
Yes.
Can a case be too tricky for a jury? Maybe factors involving
Yes.
catastrophic injury, foreign law, other technical issues.
So you have an automatic right to a jury trial in personal injury procedure in Scotland. It's one of the differences between Scotland and England. The way a defendant would have it removed from a jury trial is they would have to show that it was too complex to go before a jury. Where that tends to happen is on liability issues. Applying foreign law would generally tend to mean it's removed from a jury. There is recent judicial authority to say that Ogden calculations are not too complicated to go before a jury. So really, if you're looking at quantum issues, that's not the complexity. It's really when you're looking at difficult aspects of liability law that it's likely to be removed from a jury trial. But if you are a claimant lawyer with an amputation or a fatality, then you want a jury because then you're going to have a very sweaty insurer wondering how much they're going to have to pay.
One more question before I return to lectern. Interest on Salatium is 8%. You apply interest only to the past aspect of Salatium. So in an ongoing injury case, obviously not one where the injury is resolved, what's the approach to apportioning past Salatium so that you can apply interest to it?
Well, especially we always apply some salation to the past, some to the future. For any losses, we would have, if it's an ongoing loss, we apply 4% interest. If it's a fully resolved loss, it's 8% interest. Effectively, it comes down to a matter of submission when you're seeking how much of salation you think should be applied to the past and how much to the future. Obviously, the initial part of any injury is generally seen to be the most painful bit. So you would always get that slight bump, but it really is down to judicial discretion or jury discretion as to how much is to the past and to the future and looking at previous authorities. You want back at that?
Yeah, I'll swap back in. I did look in the CPR to see whether or not it would be possible if you were running a Scottish case in England to request a trial by jury. Rule 2611 does make provision. Within 28 days of service of the defence, you have to make an application. I then found section 69 of the Senior Courts Act 1981, which mostly deals with police officers doing things they shouldn't do. But section 69.3 does allow the court a wider discretion. I didn't find any reported cases on that, but maybe that's something that could be looked at if you really wanted to, or alternatively, you could just litigate the case in Scotland. Next slide, please. Bereavement awards. I don't need to tell you how low our awards are. The updated award is £15,120. If you meet the criteria at the top of the slide. I know that APIL continue to challenge the awards, and it doesn't fairly reflect bereavement. That said, I know under some other laws, you need to actually prove psychological harm to cover some form of bereavement. Scotland, however, seems to be a far more generous regime. Simon, explain.
So we don't have a statutorily limited award for fatal damages. So what we do have is the Damages Scotland Act 2011, which sets out who can claim following a fatality, and that is a relative. Which is section 14, subsection 1. That is effectively parents, siblings, children, grandchildren, and those adopted as being part of the family, effectively people that live as children of the family or as siblings, was always seen as part of the family. Loss of society claims in Scotland are big claims. Roughly at the kind of around 2010, around then, this was a big issue in Scots law, hence the two decisions at the bottom. Bellingham v. Todd was the interesting decision because Lord Woolman decided that there was a grand disparity between jury awards and judicial awards and fatalities. So he reviewed them all and said, yes, there's a great disparity, but I'm going to award judicial style awards in any event, whilst bearing in mind that he's supposed to bear in mind what juries say. Fundamentally failed. And it was Hamilton against Ferguson Transport, which is the inner house decision, appeal decision, which brought into our procedure the idea that juries should get guidance on effectively what they're awarding. But if you think that you get, what is it, roughly 15 grand for everyone, I think it's everyone?
No. Just those people.
Just those people. You're very, very tight. So very young grandchildren will probably get about that in our system. So if you're a spouse, say you're in your mid-20s, your early 30s, you've just got married, you'd be wanting 120, 140,000 pounds for your loss of society. Your parents might be wanting 80, 90, 100,000 pounds. Siblings, 40, 50,000 pounds. Add it all up, it's significant sums of money. You have a really big family. Glasgow Catholics have really big families. You end up with very large claims. We look at you and frown. I understand that APIL is trying to change things down here, but we still, if we have a fatal claim, we want a jury. We want to put that pressure on the insurance industry to pull out the checkbook. And what the jury is supposed to consider, as well as the judge is supposed to consider, is how close they were as a family. That's what you're looking at. It's not, and I think it's in maybe no need to prove a psychological injury. So you're not looking at necessarily the immediate impact it's had on that relative. It's what have they lost? It's they have lost this person in their life for the rest of their life. So you're looking at how close that relationship was, what they did together, how much time they spent together. One thing you'll often find, and bizarrely, is even with families where there is an estranged relative, we would get an award for the estranged relative on the basis that they've lost the opportunity to rekindle that relationship. Those awards would be smaller, but you're still saying, well, they may have fallen out in their 20s as brothers. But when they get older, silly squabbles fall away. They've lost that chance. They won't have that society any longer. So you've really got to know what your arguments are and actually look into what the family dynamic is and then kind of push that. And of course, our system of how we plead things also makes for a bit of mystery as well. So.
Here's another one, which is a bit different. Next slide. Yes, sorry, next slide. Thank you. Care is a bit different. And this is one area where down south, we're a little bit more progressive because we do not have a list of people for whom care can be recovered. It doesn't matter if you're married, share blood ties, or you're just a nice person who wants to help your neighbour who may have fractured their ankle or whatever. Scotland, however, is less generous. As you can see, there's not a common law basis for care. It's set out by Section 8 of the Administration of Justice Act 1982. It doesn't apply down here, but does apply up there. And it says when necessary services, which sounds terribly formal, have been rendered to the injured person by a relative, and then it goes on and basically says that it can be recovered. There's also specific rules to say that if they make it clear that they don't want to recover for care, that's not recoverable. So if you've got somebody who's too much of a Samaritan, you might actually end up not having a care claim at all. But Simon, what I was interested in your views on is, my understanding is if you're a friend, can't recover at all. But what's the position with, for example, someone where they're in a relationship, but they've not moved in and the girlfriend's being really helpful, or for example, it's an older bloke who doesn't want his other half to move in. What happens then? Can you recover for care?
Well, just going back a little bit, we have Section 8 and we have Section 9. So it's care that has been rendered to you, and you can also claim for your inability to render care to other people. So, for instance, if you would normally look after your mother, but for whatever reason you can no longer do that, you can claim for the cost of that care as well. Normally, it is relatives. If you are in a relationship, I think we would generally say, yes, you can claim for that. I don't see a defender really going to proof on whether or not you can get that. Friends, acquaintances, no, you're not going to get anywhere with that. It has to be either a relative or someone you're in a relationship with. And I would say in a relationship, not necessarily living together. I think technically, yes, but the reality is you're not going to go to proof on, well, they were at that stage of the relationship, but they weren't quite living together. I think a judge would give you something there, basically. So that's that. Okay.
Anything else? The other question was rates of care. Is there a reduction to reflect the gratuity of the care provided? How do you approach rate of care?
Is it in terms of the hourly rate? I think we would probably look at it in the same way that you do. You get facts and figures, get your thing, and then reduce it for tax. So pretty much the same rate as you.
But do you then knock something off to reflect the fact that it was provided by a family member?
No.
There we go. I'll let you stand back and you can deal with accommodation and PPOs. Next slide, please.
I suppose the question is for the English people in the room, or the Welsh. I don't want to forget the Welsh. We were hiding the Welsh dragon earlier. Accommodation claims, Swift v Carpenter, yes, that would be followed. We don't have any authority following it yet, but I'm aware in my own cases when I've got housing cost reports, they're valuing it on the same basis. I would expect we'll have a court decision confirming it sooner rather than later. PPOs are slightly different. You will see that there is an act listed there. So we have passed some law on it. Are we doing anything with it? The answer to that is no at the minute. So yes, the Scottish Government has said that the court should be able to award PPOs. Where that presently is, as I'm informed by one of my partners who's in the relevant committee for this, is they are drafting the court rules to enable the court to be able to award PPOs right now. That doesn't mean we don't have PPOs at the minute. It simply means they're not ordered after proof by a court at the minute. You can have them effectively by agreement at the minute. That is why Dee's parents against the Greater Glasgow Health Board is up there, because that was where a periodical payment order was agreed between the parties. The health boards, as you know, are keen to agree PPOs for financial reasons. it was agreed, and what they did, or the parties did, with agreement from the judge, was set out how they think that should happen in the future, and the relevant documents you should be lodging with the court to get the court's confirmation of the agreement. So if you have what we would call a joint minute, which is effectively our contract of settlement setting out a PPO, a court will grant it. They just can't at the present time order it themselves after an investigation into quantum. So we're getting there. We will have PPOs in full soon. How soon, I don't know. That will depend on the Lord President's office.
Next slide, please. I think this is probably you as well. When you think it would be more appropriate to litigate in Scotland, trying to be as objective as you can, of course, but it strikes me that you've alluded to Scottish procedure and some of the differences with regard to exchange of evidence, and you focused on juries. So maybe if you could focus on those.
Well, as a partner in a Scottish law firm, I would always say you should litigate in Scotland, of course. That's my business. So obviously, if the client is domiciled in Scotland, it's obviously easier for them to litigate there, particularly if you're applying Scots law. You are going to pee people off, I think, a little bit if you're applying Scots law in England with a person in Scotland. The decision about the County Court of Carlisle of Scotland, as it was, might find more traction. Scottish procedure is very different to yours. Whenever we get, and we do get, English files passed up to us not far from the triennium, with lots of things that we don't do prepared. So our procedure is effectively designed not to bother courts. So we would generally only be seeing a judge if we were falling out about something. So a court produces a lovely timetable, which we follow and we lodge things, but that's our valuation, it's our pleadings, and it's our documentary evidence. We do not lodge witness statements, which you'll find surprising. So what our witnesses are going to say is a mystery to the other side, which is sometimes wonderful. Sometimes obviously not wonderful when you don't know what the defender's witnesses are going to say, but that's part of the mystery of it. We have a system called abbreviated pleadings. So all of our court documents in applying personal injury procedure, they have to set out 6 things: who the parties are, why you have jurisdiction, the basic facts, what the losses are, and which law you're relying on. And the guidance and all of it has expanded a little bit. It used to say, are you relying on common law or statutory? We've expanded a little bit due to rules of fair notice. You can't simply put common law any longer. That wouldn't go down quite so well. But that allows you effectively to have a little bit of mystery in terms of what your case is. So where you've got a case which potentially might not be the best, that's quite advantageous to you because, quite frankly, the defendant does not know what it is they're going to be faced with. That can often be the case with, EL cases where your guy was the only person there when the accident happened. They don't know what he's going to say and they're not allowed to talk to him. So mystery, are you going to take that to trial in your case or not? That is entirely for the defender. Of course, we have jury trials, which will affect quantum. That's there. Advice to client regarding success fees. And the reason I put that there is simply that success fees are now limited by statute in Scotland. So the only thing that I would worry about is if you were acting for a Scot applying Scots law and you signed them up to a success fee which was greater than the statutory cap in Scotland, then they might wish to pursue you after for the difference if you hadn't advised them of that statutory cap and sold the benefits of you to them at the outset, because you probably should be advising them of their options so they're fully aware of the situation. Anything else, Ian, that you want me to discuss?
No, that's great.
No.
Next slide, please.
Is this me again?
Yeah, it can be.
Okay.
Yes, I think so.
Well, the practicality, I think, is pretty much the same as practice handing a file over to anyone. The one thing I would say, though, is because of our system whereby we have to raise and serve, ring us up the week before a triennium with a Scottish case. We've got this case. We've just figured out, well, we really don't have jurisdiction. No, the insurer doesn't really want to engage. Can you litigate it? You go, with a week? Where's the defender based? Oh, right, okay. Oh, it's a foreign defender. Oh, good luck, bye. The reality is, if you are serving abroad, 3 to 6 months is your average. I had one in Norway, which is actually, we're still in the presence of doing a Section 19A argument because the Norwegian court took 16 months to serve something, and our instance falls after a year. So by virtue of putting it in a drawer in Bergen, the instance fell, which is a bit of a nightmare. It means basically the action is no longer in action. Basically, the court no longer has authority over the writ. So we have to have things sufficiently in advance of whichever relevant time limit it is, so that we can not only sort the necessary papers, get them to court, get them signature warranted, and then get them served. We don't like things at the last minute. You want to have them well in advance so that you can sort them. And bear in mind, particularly if you're doing foreign law, of all the different time limits we know about. Of course, in many countries, you can extend the time limit. Spain, we all love to extend that 1 year over and over again. Athens and Montreal, obviously 2 years. Bear that in mind. Of course, we'll ignore Warner against Scarpa Flow number 1. We don't know yet whether Warner v Scarpa Flow number 2 will turn up on our doors. But there are these things to bear in mind. It is a bit of a minefield. As I said, I discussed roughly what our procedure is. So we're really fast in Scotland comparative to you guys. We find it quite funny when we get your decisions. It's like, an accident happened 7 years ago. We're now deciding on it. And we're going, what took you 7 years? It's almost bizarre. So the CPPS, we don't have portals. You guys have your portals. And I think anything below 25 grand goes into a portal. Is that right? Correct me if I'm wrong. We don't have that. We have the CPPS, which applies to anything under £25,000. Which sets out timelines and also how much costs, to use your terminology, we would recover in the event of it settling. That takes roughly 5 months from start to finish. And if it doesn't settle in that 5 months, you litigate. But if any part of it is breached by a defendant, you litigate. And the initial time period is they have to respond to you within 21 days. So you can be in court within a month of an accident if you really like. Not always the most sensible, obviously. And then, as I say, Chapter 36 and 43 are the standard forms of personal procedure in the two different courts. We do have case managed cases, which is the ones with the A's. And that's where you would actually have a judge case managing what's going on. And that is for more complex cases. I'll not get into privative limits. I don't want to bore you with which court you have to be in based on the financial value of the case. The warning is Kirkwood against Thelum Assurance. It is a French defender. English UK-wide firm of lawyers. This actually came out this year, a couple of months ago. UK-wide firm of solicitors. Person injured goes to their Glasgow office, says, I'd like to instruct you. They go, great. And they pass it to their Birmingham office. Their Birmingham office does all the work. They settle it. And then the defender goes, yes, but we're not paying you. And they go, but why? We've done all this work. Here's our account, we've done lots of work. And the defender says, yes, but if you look at our court rules, they say that you can recover costs of Scottish solicitors in Scottish courts, and you're not Scottish. And so they took this to appeal, and the court went, yes, our court rules say you can recover for Scottish lawyers in Scottish courts. You're not Scottish. What you can recover for in terms of instructing foreign lawyers, obviously if they're acting as an expert, or if they're doing some investigation. If, for instance, your client lives in a different country and you want to get their medical records, you can instruct a foreign lawyer to do that. But you cannot let someone from a different country do all the work and then claim for it, because that simply falls out with our costs regime. And I think that the loss there was 130,000 to UK-wide firm of lawyers. I don't think they're appealing further, but I don't think anyone in the room is from that firm. But they might be on the webcam, so they might hate me. So I'll step aside.
Next slide, please. Finally, just looking at the impact on Brexit, because we can't get away with not talking about Brexit. Packages are still packages. Athens and Montreal, you've already mentioned. Brussels, sadly gone. Do you have jurisdictional gateways for tort claims, Brownlee equivalents in Scotland, or is it even more doom and gloom north of the border?
You've always got to watch what you say when you cross the border, because I'm aware I'm now in Brexitania Unchained. It's funny coming to a country where you supposedly don't like the Europeans, whereas we do just because we don't like you, seemingly. I'm yet to figure out the logic of either. No, we don't have a Brownlee equivalent, is the obvious way of putting it. We don't have tort gateways. What we have is Schedule 8 of the CJJA. If it's not in that, we are scuppered with Brussels 1 disappearing. Obviously, Athens and Montreal are the same, and they have their own jurisdictional regimes, etc., etc., etc. Yeah, I can go into more depth, but let's not bore you all on a Thursday afternoon.
Okay, next slide, which I think is the last slide. And as Simon pointed out, you'll see number 7 there. I didn't realise, and sorry, Mark, there's no Welsh on that particular photograph. But number 7 is Hamish Watson. And I would like to show, shows Anglo-Scottish cooperation, if you will, because Hamish, although having the most Scottish name you can imagine, is born and raised in South Manchester. When he opened his mouth in the last BBC interview, I was quite surprised to hear that he's got a strong Manc accent, which is my adopted town. He's currently doing battle for Edinburgh and playing for Scotland. So I thought that that's a nice way to end the talk. Does anybody online or here have any questions of Simon or me?
I was going to say Hamish. He looks English. He sounds English, but he's just a little bit different. You should have picked him before we did, quite frankly. Any questions at all? No questions? I can hide and eat all the millionaire's shortbread now, can I? Like a proper Scot.
That was a brilliant talk.